Welcome to Property Law 101. I'm Sara Bronin, and I created this series so you can understand the basics of property law. So we talk about 4 fundamental questions in this series, and today we are talking about the second one, how we come to acquire property. So we've all heard the phrase finders keepers. The full phrase is finders keepers, losers weepers. And the phrase is all about property ownership. But this phrase isn't necessarily true in all instances. And the reason is that property law considers claims to an object to be relative. One of the classic English cases that demonstrates relativity of title is Armory versus Delamirie. In that case, there's a chimney sweep who finds some kind of jewel mounted in a socket. He takes it to a goldsmith whose assistant takes the gemstones out of the socket and then gives it back to the chimney sweep saying, what you brought in is worth very little. The chimney sweep brings an action in trover against the goldsmith and the apprentice. So trover is a lawsuit alleging a wrongful taking of property. What happens in court illustrates the principle that title is relative. The court says the true owner will always be the rightful owner of the jewel. But here, looking at the parties who are actually in court, the court says that the finder is the keeper. The chimney sweep prevails against the goldsmith and against the rest of the world. In a lot of ways, the facts of that case, the Armory case, are pretty simple. But consider another scenario. So let's say the owner of the building with the chimney claims that the jewel belongs to him because it was found on his property. So in considering this question, the court's answer might depend on whether the jewel was lost or mislaid or abandoned. If we think someone mislaid the jewel in the chimney by intentionally placing it there, then perhaps the property owner has a stronger claim to the jewel. The property owner would certainly have a stronger claim if the jewel were found in a little box buried in a hole in the yard. That demonstrates intentionality of placement. Now consider whether the employer of the chimney sweep might be able to claim a superior title to the chimney sweep. The theory of the employer might be that the chimney sweep found the jewel during the course of his employment. Now, this might be a harder case in your mind, but consider the employment situation of somebody who cleans hotel rooms. Usually, the employer, the owner of the hotel, demands that people who are cleaning rooms turn in items that they have found to the hotel lost and found. The assumption there is that the owner of the hotel is in fact the owner of any property that might have been mislaid in the rooms that the hotel contains. So now consider an American case, 1866, McAvoy versus Medina, another case that we see in a lot of property law books. So in that case, there's a wallet that's left in the barber shop. A customer finds it and gives it to the barber. In that scenario, the owner never returns. So the question in the case is, who gets to keep the wallet? Is it the customer who found the wallet or the barber who owns the business premises in which the wallet was found? One thing to consider is how this case is different from the Armory case. In that case, the property is the wallet. It is more like mislaid property than lost property. It's not lost property here because the item was actually placed inside the shop by someone intentionally. So we call that mislaid property. When objects are mislaid, finders only get to keep the property if it is not reclaimed. The idea behind this rule is that true property owners are more likely to go back to the barbershop to make the claim for the wallet rather than a transient shopper. So in this case, the transient shopper, who is the finder in the case, the court says is not necessarily the keeper. supposedly rewarding the barber with ownership will better secure the rights of the true owner. Again, because the true owner is much more likely to go back to the barber shop and ask the barber where the wallet is than somebody who just maybe stopped in that day to cut their hair. So how do these rules apply when you walk into a classroom and see a laptop on the table? Without a sign indicating that the laptop was abandoned, you can assume it was mislaid, that it was set there intentionally, not accidentally, but also that it was not abandoned by the true owner. If you look at the principles of the McAvoy case, the educational institution that owns the premises in which the classroom is located might have a better claim over the laptop than you would. On the other hand, a court might split property rights. So for example, it might say that the priority for the laptop goes to the owner of the classroom for some period of time, say 6 months, but if no one comes to claim it, it goes to the finder. All of this is to say that finders don't necessarily have absolute property rights because a true owner's claim will trump all others. However, the finder has rights greater than third parties who are not the true owner unless the owner of the premises might be, in the court's estimation, someone who may be the more responsible party for ultimately getting the property back to the true owner. So once again, title is relative. There are many different factors that a court or you will have to consider in determining who actually owns something that is found. So I'm going to leave it there, and I look forward to engaging with you on Twitter or through my website, where you can sign up to my mailing list. See you next time.